Okay, I'm showing 2 minutes after the hour, so let's go ahead and get started. Sam, if you want to start the recording, if you haven't already. Today, we're delighted to have John Dartley with Perlman & Perlman joining us to share some great information related to data privacy. Some of you work with JMT already, some of you may not, but if you don't know, JMT is a technology consulting firm that serves nonprofits in their back office technology needs, accounting, HR, CRM, payroll, budgeting, you name it, any type of technology system. And with those systems, inevitably comes data. And anytime you have data, there are implications for that. So John's going to be sharing information on data privacy. And John brings a lot of specialized knowledge and experience in this area. It's an area of specialization for him and for Perlman & Perlman, a law firm that serves nonprofits nationally as well. So we're super excited to have John on board with us today. John, if you'll go down one slide for me, please. This
Sure.
This webinar today is one in a series of webinars that we have coming up. If you go to our website, jmtconsulting.com, you can see that we have a lot of information that we share ourselves and through our partnerships, like today with John and Perlman & Perlman. So without spending too much time on an introduction here, I'd like to turn it over to John, who's going to take us through the next hour on data privacy. So John, you want to go ahead?
Great. Thanks so much for the introduction. And thank you to all of JMT for making this webinar possible. So let's assume you're a long-term donor to a nonprofit, and you just learned that your credit card information, the information you provided as a nonprofit to make a donation, are now in the hands of a hacker. How would you feel about that organization going forward? Would you trust it the same way as you had in the past? In a recent article in the Nonprofit Technology Network News, an author made an argument that I've made over the years that while data breaches occur for for-profits and government entities, nonprofits are probably more susceptible to reputational harm. This is because consumers' relationship with a company or a government entity is typically based upon a consumer's need, whereas his or her relationship with a nonprofit is not necessarily need-based. So nonprofits may be a greater risk for reputational and financial damage in the wake of data breaches. Although data breaches seem to be increasingly common, most organizational leaders still know very little about the risks that can arise from the collection and storage of personal information from both employees, volunteers, clients, or donors. And while my experience with working with for-profit companies is that it's often privacy and cybersecurity has really been a what we call a C-suite issue, meaning that there's typically a senior level person in charge of it. Nonprofits have been a little bit late to the game. Considering the risks, the fines, and even the potential for civil and criminal liability, today I'm going to try to provide a framework for what you must know and understand in order to fortify your organization against the associated risks of a cyber event. Now, I will be giving a lot of information to you. It may be a little bit overwhelming, so feel free. I know there'll be copies of this PowerPoint. If there are questions, we'll have a question time afterwards, and you can always reach out to me, email me, or call me with additional questions. And if at times it feels like I'm trying to scare you, that is probably intentional. Over the years, I've seen a lot of bad things happen to good people, and many of those things can be avoided by putting some precautions in place, thinking more holistically about privacy and cybersecurity, and making it kind of a top-level organizational concern. So, organizations experiencing data loss grows each year. As you can see from this slide, in 2017, it jumped up once again. We expect in 2018 to once again surpass 2017. The cost can be immense. The average breach cost is $3.5 million. And many U.S. companies will experience a breach that costs them between $1 million and $3.8 million. Nonprofits, no surprise, are not immune. It's not the for-profit world. While you hear more about it, the nonprofit world has 63% have suffered a data loss. Many of them may be smaller, so you haven't heard about them unless you're actually donating to the nonprofit. These data breaches involve hacking, physical breaches such as theft of device or stolen files, or vendor or third-party breach. And we'll talk a little bit more later about how you can work with your vendors to better make your nonprofit secure. But often, I would say the majority of breaches will occur from a breach with your third-party vendor. So let's talk about personally identifiable information. What is it? Personally identifiable information is any data that could potentially identify a specific individual. PII, what we call PII, can be either sensitive or non-sensitive. When you think about non-sensitive PII, think about public records, phone books, names and email addresses. While they still need to be protected, they don't need to be protected as much as sensitive PII. Sensitive PII is information that really is not public, things like social security numbers, credit card numbers. If you're collecting sensitive PII, and we'll talk about later if you do a data privacy audit, you should have a really good handle on the kind of data you're collecting and why you're collecting it. Most organizations that collect PII, sensitive PII, probably don't need to. But if you are collecting that type of information, you definitely want to make sure you have the right provisions in place and the right security in place to protect it. Only because if there is a breach, sensitive PII comes with higher fines and higher risks. So why is protecting PII important? Well, obviously, it could be a long-lasting effect on the organization. We've talked about trust, right? They could be financial. There certainly could be, depending on the state you're in and where the breach occurs, there can be financial costs. There can be civil liability and even criminal liability. So, how to protect PII? Excuse me. There are a variety of laws that protect the way an organization collects, use, and shares information. In the U.S., it's really a patchwork. To give you an example, both Massachusetts and California have much stricter laws than many of the other states. The U.S. is probably moving to at some point national law, federal law, but that's going to be a few years in the making. But it's important for you to have a sense of in your organization what laws apply to you. If you're not sure, you should ask an expert. Okay, so let's get focused, talk to some about best practices and recommended actions to take today. First step, website privacy policy. Most organizations have them. Many still don't, but most have at least what I call a cursory website privacy policy. Basically, a privacy policy is a legal document that discloses all the ways a party gathers, uses, and manages the customer or donor data. This is not something to take lightly. I always recommend clients as a first step because it really tells your donors or your supporters how you're using the data. It's more or less your promise to them. What I always say is say what you do and do what you say. In the privacy world, there's not much you can't do in terms of collecting data voluntarily from people, as long as they're aware of what they're giving you and how you're protecting it. Having a solid policy is important not only to avoid trouble in the future, but also to insulate the organization should there be an issue. We've all heard what happened with Facebook. A lot of the backlash that happened was because they were not disclosing what they were doing with the data they were collecting. Had they disclosed it, there probably would not have been the uproar, and there was some reputational risk. But the difference between Facebook and a nonprofit again is that for many, Facebook is a utility, so it's hard for them to leave. So, crafting a privacy policy. What should be in there? It's important your policy can be understood by everyone. Donors care about what is happening with their information. One of the first things that a customer does or a donor does when they arrive to your website, often, at least I do, is look at the privacy policy. So try to write it in basic English. Try to put everything you do in terms of collecting both personal information and non-personal information. So the policy, again, should be in simple English. Think about like a 9th grade level. It should inform customers about what information will be collected and whether it could be identifying or not. You should talk about who you share information with, and certainly if you share with advertisers or third-party marketers. It should make opting out easy and explain how they can do that. And it should also state that your policy should be updated regularly. Now, I know the organizations that I work with who have privacy policies, typically they were drafted 5, 6, 7, 8 years ago, have never been updated. The fact is, as we all know, organizations, nonprofits are getting more and more savvy about the marketing they do, about how they share data, about how they reach out to donors. I can guarantee you that any privacy policy written even a few years ago is probably not up to date in terms of the actual back-end practices. So I always recommend once a year, look at the privacy policy, make sure it's still accurate, and if not, update it. 2 things to keep in mind. Don't forget a terms of use. A terms of use, while a privacy policy is a disclosure about your back-end data gathering and sharing practices, a terms of use actually is a legal document that protects your organization and allows you to enforce certain obligations and then certain issues on your website. So it's an important document that helps you limit liability, disclaim certain warranties. The other thing you should keep in mind is a donor policy. Now, most organizations still don't have a separate donor policy. For those who care, Charity Navigator, for example, often takes a star away or deducts points if you don't have a separate donor policy. A donor policy, I should one step back, a privacy policy typically only deals with information collected online through your website. A donor policy will talk about online and offline practices in regard to donor information. So a best practice would be to have a link for a privacy policy, a link for a terms of use, and a link for a donor privacy policy. Okay, so how do you get a handle on the kind of data you have? As we talked about before, the headlines reveal that data privacy breaches are increasingly common, and the potential negative consequences to your organization in terms of reputational damage, potential liability, and costs are increasingly high. To avoid these consequences, any organization that collects, uses, or transfers personal information should take steps to get a handle on exactly what they're getting, who's getting access to it, and how it's being shared. Here, I talk about if you remember the 5 W's and the H, right? The what, what data does your organization collect? It's important to kind of have a sense of what that data is. Why is the data being collected? Given the fact that now data is valuable and the loss of data can be damaging to your organization, you should only keep the data that as a rationale for having. Who has access to your data? Is it employees? Is it volunteers? Is it third-party vendors? Where is the data stored? When is the data deleted? And we'll talk more about each of these things going forward. Your organization, if it doesn't have it, should have a data deletion plan. Basically, you should only keep the data for as long as you need it, and then you should securely delete it and destroy it when you no longer need it. And then how is data collected? So let's talk about a little more about what a data privacy audit would look like. It does not need to be expensive. It can be more informal, meaning it's working with an internal team, but with the proper tools and a motivated audit team, you can typically find out a lot of the information that we're talking about in terms of privacy audit and take steps to better protect your organization. Broadly speaking, there are 2 types of privacy audits. One is an adequacy audit. Basically, you're determining whether the organization's data privacy policies are adequate to address the requirements of the applicable laws that affect your organization and other regulations. This type of audit involves not only a review of the company's policies, procedures, codes of practice, and guidelines that affect the handling of personal data, but both within the company and dealing with third parties. An adequacy audit, if done correctly, will often show you some gaps, things that you have not been doing that you probably should to better protect your data. Then there's a compliance audit. A compliance audit basically assumes you have a good handle on your data practice, your data gathering practices, your sharing practices, how you protect the data. And what a compliance audit does is sets a higher bar. It's basically a comprehensive audit that examines all the ways you're collecting, holding, sharing data, and making sure you're complying with your own policies and best practices. Let's just wait for that one. So in order to do a privacy audit, what I typically provide a client is a set of questions. It's a few pages long. It's really based upon the organization, tailored to the organization, and allows my clients to kind of go through ask a number of questions across a broad areas. So talking about vendors, talking about employee, talking about how data is stored, talking about how data is shared, talking about how data is transmitted, and seeing whether there's any trouble points or any things that need to be addressed. For example, what types of personal data is being collected? You want to get other names, other telephone numbers, or you're getting social security numbers. How is the personal data being collected? For example, is it hard copy? Is it online? Is it by telephone or third parties? How are you getting consent? And we'll talk in a few minutes about the new regulations coming out of the EU. If you're collecting any information from a European citizen, or I should say resident, how you're getting the consent and how you're documenting that is vital. What steps you're taking to ensure the accuracy of the personal data is maintained, and how long is the personal data being retained? What technical organizational security measures are in place to protect the data? Again, if it's in a file cabinet, is the file cabinet locked? Are people putting it on their home devices or computers or phones and taking those home, and are they non-encrypted? Certainly, is personal data being shared or disclosed to any third parties? You want to get a sense of, is it volunteers, is it third-party vendors? You need a list of those, especially when you terminate a vendor or terminate a volunteer. You need to make sure the access is no longer there. Okay. So let's talk some specific tips in terms of data security strategies, sorry. You want to ensure you regularly have software updates. I can't tell you how often people fail to literally use the patches that are provided to them by their vendors, and that can cause a breach. You want to make sure all data is encrypted, that's sensitive. You want to schedule data security training. In fact, if you have a cyber liability policy, some actually offer yearly training. You want to have what we call a BYOD policy. This is bring your own device to work. These days, as we know, most people have iPhones or other devices besides what an organization might give them. Actually, more and more I see most organizations I work with actually don't give their employees any kind of devices. So you need to have a policy in terms of what people can put on there, how they're sharing it, who has access to their phone. Data, we touched on having also a data retention policy. You definitely want to have a sense of how long you keep data and then when you delete it. Okay. Also, you want to train, we talked about training, implementing firewalls, make sure you have strong passwords, make sure you have antivirus software, make sure your physical information that you're storing, everything's locked. But many of these things I know sound simple, but I can't tell you how often when there's a breach, it's for those kind of simple things that should have been done that weren't. Those are just a few of the things I just mentioned. Okay, so some more practical tips. Review contracts with vendors that collect, process, and hold your PII. Again, in the majority of instances now where everything's moving to the cloud, if there's a breach, often it's because of a third-party vendor. And we're going to talk about specific provisions to make sure you have in all of your agreements to protect your organization. The other is think about insurance coverage. And we'll talk a little bit more about this in detail later in the presentation. But a lot of organizations are under the assumption that they have a general liability insurance, they're covered. You're not. General liability insurance coverage and any other type of insurance policy typically only deals with physical data. It does not cover, and in most policies, it's specifically excluded, is any kind of digital data. So you need to really think about having a good data breach cyber liability policy. Okay, so third-party vendors risk management. Organizations, again, are increasingly relying on third parties to provide critical services and to host their PII. Unfortunately, these vendor agreements are typically very one-sided. And I say that as somebody who, for a few years, was at Blackbaud, which I think most of you know. I was their Senior Deputy General Counsel and Chief Privacy Officer. I wrote their standard vendor agreement. Now I have the pleasure of negotiating those agreements on behalf of my clients. And it's for one client who was doing a very large transaction. It was a 6-month negotiation. We had to basically rewrite the agreement. And the general counsel joked with me, "But John, you wrote this contract." I said, "I know, but when I wrote it, I was on your side. Now I'm on the other side." And quite frankly, it's not anything to do with Blackbaud. Routinely, just about any third-party technology vendor agreement I see is about as one-sided as it possibly can be. And that's because they're smart. They realize they're handling data. They're handling data that can have big consequences if it's breached, and they're doing everything they can to kind of minimize their risk from a commercial standpoint. That being said, in almost any vendor contract that I work with, we're always able to get key provisions in there to help protect you. So let's talk exactly about the types of protections I'm talking about. This is not an exhaustive list, by the way. I know a lot of people often look at a contract and they'll quickly mark it up internally and then maybe just cross a few things out. But the thing you have to keep in mind, it's often not what's in the agreement, although there are things you need to address that's in the agreement. But it's all the provisions that are not in the agreement, things that need to be added in there to better protect your organization, make sure you're getting what you're paying for, what you expect to get, and then if something goes wrong, making sure you're covered. So the following is a list that's not meant to be exhaustive, but definitely every one of these provisions should be addressed in any third-party vendor agreement that you have, people who have access to or are holding on your behalf personal information. Representations and warranties. These are the special promises that are often in an agreement that if there's a breach, it's clear there's no argument, the vendor is at fault. Typically, in the first draft of a vendor agreement, it'll simply say we represent and warrant that we have the legal ability to enter into this agreement, and maybe a couple other cursory statements. Not surprisingly, I add a lot into this section. For example, during the pitch phase, I know salespeople often promise all types of things to how the software will work. They'll give you shiny, glossy pages that show you about all the functionality and features. That should be a representation of warranty. I often attach the marketing materials to the contract and say that the vendor represents and warrants at the signing of the agreement, that the software you're purchasing will work in compliance with the attachment A that describes how everything's going to work. You also want to make representations and warranties that are doing proper security, that they're maintaining confidentiality, that there's been no breach in the past 5 years. Privacy and security. Once again, if you're dealing with these vendors, they always tell you about the top tier, first class, best in class privacy and cybersecurity precautions they have, and why you shouldn't worry. And yet, in almost every vendor agreement I've seen, there's one statement: the vendor will take commercially reasonable precautions to protect your confidential information. Something similar to that, or they have reasonable physical, administrative, and technological precautions in place to try to prevent an event, a cybersecurity event. That's simply not enough. And again, what I've often done is add a page or two into the agreement about all the other specific things that they should be doing. They should be encrypting. They should have firewalls. They should be having patches that are updated. And the reason why you want that in there is, should something happen, they'll have no liability if they could say they've taken reasonable precautions. And what reasonable means, it's really up for judgment and debate and arguments among lawyers. If you have specific obligations that they have to take, it's much easier if there's a breach to show the fact that the vendor was at fault. Limitation of liability. This is one of my favorite ones. Every agreement, limits liability. And typically it's to what's been paid in the prior 6 months of the contract, maybe 12 months if you're lucky. As we all know, a lot of these agreements, you're not paying a high monthly fee. And if there's a breach and you're losing thousands or tens of thousands of donor names, the costs associated with fines, with if you have to notify people, if there needs to be a hotline, if there needs to be insurance coverage or credit monitoring, can be immense. So in any limitation of liability, there need to be carve-outs. There need to be carve-outs for IP infringement. There needs to be a carve-out for any breach of security or privacy, or confidentiality, and probably a few other carve-outs, any kind of gross negligence or willful act. Again, this will never be a vendor agreement, the first draft, but with all these provisions, in almost every case, I'm able to negotiate most of these terms in. Next one, indemnification. This is a pre-agreed commitment for the organization to cover certain third-party damages. Not surprisingly, any kind of breach, any kind of cybersecurity event, they should indemnify you against your third parties. Disclaimers, as mentioned earlier, even though these agreements are very light on representations and warranties, they usually disclaim a lot. A lot of what they disclaim isn't appropriate, so you need to address that. The next two, I would say, are probably one of the two most important. Breach notification. I will say that I've never had a vendor say no to this provision. I've had them push back, and we've had to go through multiple rounds. At the end of the day, I've never had a vendor say no. And basically what a breach notification provision says is that if there's a breach, and if it's because of a failure or act or omission of the vendor, that they will pay for all statutory costs, for any credit monitoring, for any other costs associated with the breach. Again, these fines and these actions can be tens of thousands, but I've seen them hundreds of thousands, if not more. So having this provision in your agreement is key. And finally, transition services. I always recommend this goes in as well. Listen, all vendor relationships in the beginning seem rosy, but not surprisingly, we've all been there. Some don't work out. When they don't work out, some vendors are better than others, which helping people to transition to the next vendor. Right? Some intentionally make it difficult. So again, in every agreement I write for a client, and again, I've never had a vendor say no to this. You mandate that for a 6-month or 12-month period, if you're moving to another vendor, they have to keep providing you the same services at the same rates you had been paying, and they have to work with you reasonably, and they could charge additional fees if you need their work in order to get your data off their system to your new vendor. Okay, cyber liability insurance. Let's just talk about some of the basics. It's very important to have, if you're having personal information, the policies obviously range in cost, but depending on how big your organization is and how much data you have, they're typically reasonable, and they're very important because you cannot always rely on your vendor. Even with the best contract in place, vendors go out of business, vendors refuse to pay. There are things that happen that may not be the vendor's fault. Right, a lot of these breaches can occur on your organization side. So having a good cyber liability insurance policy is key. Some of the things that they should cover are notification expenses. As I mentioned, most states have notification requirements for both private and government entities. Many apply to nonprofits. So those costs can be immense. So you want to make sure your policy covers that. Crisis management, after a data breach occurs, you've met the notification requirements, your nonprofit can still face harsh criticism and scrutiny. So having a crisis management team can be very important. Regulatory and investigation expenses, a data breach can, again, talking about the notification, can be very expensive. So you want to make sure you're covered there. You want a data breach liability, coverage that will defend your organization against legal claims, and this is important, that can be brought against your organization for the failures for you to take the proper precautions. And then some policies offer content liability, data loss and system damage if you have to restore or you have to do new things or buy new servers, and often business interruption. One more caveat about insurance. Let me just slide down here. Oops, sorry, nope. One more caveat about insurance is, this is an interesting story. We had a very large client, tens of thousands of donors, had a very expensive cybersecurity policy with a well-known insurance agency. They gave me the policy just to review, and not surprisingly, the policy was really not appropriate for the nonprofit organization. It was drafted as if they were a vendor holding names on behalf of other clients or customers. It was not drafted from the perspective of a nonprofit. In fact, most of the things that would have occurred that would have caused this organization harm was excluded. Nobody read the policy. So it's important to get a policy. It's also important to read it, and yes, you can negotiate it. Most policies I've worked with on clients, You can negotiate exclusions. You can negotiate caps. So again, it's important to have somebody in your organization who knows a little bit about this. Read it. Okay. GDPR, it's here. I used to have a slide that said GDPR is coming. Many of you may have heard about GDPR already, because if you have a Facebook account or almost any other account, Netflix, you've been getting over the last few months an email message where they changed their privacy laws. I'm sorry, they changed their privacy policy. And this is really, in fact, because of GDPR. So GDPR stands for General Data Protection Regulation. It was put in motion in January 2012. And at its core, GDPR gives a whole new set of rules designed to give EU citizens more control over their personal data. Fundamentally, every aspect of organizations these days rely on data, from social media companies to banks, retailers, to nonprofits. Right? Almost every service we use involves the collection and analysis of personal data. GDPR, for anybody that collects personal information from the EU, is a game changer, because it redefines what you can do with the data, how you can collect it. You can see their fines are immense. It can be 4% of your organization's revenue or 20 million euros, whichever is greater. So, does GDPR apply to your organization? For most, the answer is probably yes. Technically speaking, the GDPR applies if you collect any information from anybody residing in the EU. And I use the word residing as opposed to citizen because it really comes down to their physical location. Technically, if an EU resident is in the US and you gather their information, GDPR wouldn't apply. If, on the other hand, if I'm in the EU and I provide your organization my information, technically GDPR does apply. Most organizations these days, if you're collecting information from around the world, if you have information of EU residents. Depending on how much you have, will depend on how much you think about complying with this new regulation. The data that's covered, by the way, it's very broad. Personal information is now considered, let's put it this way, it's so broad that any information you collect will be considered personal information. An email address, personal information. A photo, personal information. An IP address, personal information. So let's assume GDPR applies. What do you need to do to comply? First of all, if you haven't done this already, you need to formulate a plan. You need to work with the internal folks through all departments. And I think I have shared with JMT, I have a GDPR readiness checklist. It covers basically everything your organization needs to do to make sure it can or will comply, and that will be made available. You want to examine the information you're collecting. You want to look at your data governance policies and procedures. There are a variety of things that you want to take on, but let's talk specifics. You want to update your website apps and privacy policy. This is really important. This is what I call the low-hanging fruit. If the EU wants to see whether you're complying with GDPR, the first thing they're going to do is look at your online website privacy policy. The privacy policy now has to have specific provisions in there to address GDPR. You need to look at your vendor contracts. You are now personally responsible for all your vendor agreements. So if they do something wrong, you can try to pass the buck, but the EU will be looking to you. So you need to make sure that you're mandated now to have certain provisions in your vendor contracts to ensure that your vendors will meet GDPR. And it's not enough just to have a statement, they will meet GDPR. You literally need to list out all the expectations, because from an EU perspective, they can't trust that the processor understands the implications of GDPR, which means it's your obligation to tell your vendors what they need to do. Just to give you a quick idea of some of the changes under GDPR, you now need explicit consent. That's a new opt-in. You can no longer do an opt-out, and even a general broad opt-in is unacceptable. GDPR requires that an individual really signals his or her agreement with a statement that's literally a clear affirmation and action. It needs to be specific and tailored. As we mentioned, you're responsible for your third-party vendors. There's limits on data retention. We talked about having a data retention policy. GDPR specifically says you can only keep the data for as long as it's reasonably needed, and it'll be much stiffer and steeper fines if there's a breach and you've had data, let's say someone who has donated once 4 years ago, never came back, never opted in. If you're still holding that data, that'd be, from their perspective, much more egregious. There are additional rights to control personal data. So just so you know, any individual that gives you the data has the right to know what you have on them. They can request it, and you need to get them their data, tell them exactly what you've gathered on them. Portability, they're allowed to ask you to give them their data and take it somewhere else. And the right, I like this one, the right to be forgotten. They can ask basically for their information to be deleted from either on your database or any of your vendors. And now you have, that's just the notion of a good example of a vendor commitment. You need to make sure that your vendors can comply. And there are also new data security breach notification requirements. You need to notify an EU resident within 72 hours if there's a breach. Okay. So when good things happen to good people, bad things happen to good people, sorry, data breach. Again, data breaches are more and more common. Don't panic. You should have a disaster response plan. If you don't have a disaster response plan, you can panic a little bit, but you should probably work on getting one in place. Basically, disaster response plan is just a written document that if something happens, you know, who in the organization gets involved, who gets called, you know, who's available 24/7, what outside experts or vendors or resources you can call upon. Because again, the quicker you address a breach, the better it is in terms of probably minimizing any risk and certainly lowering your damages. Make sure, see if there are any federal, state, or laws that apply. And if they do, there are certain notification requirements you need to meet. Again, having a contact person, know how to talk to your vendors. And that, I think, concludes my presentation. Like I said, I realize I did throw a lot out there, and we covered a lot of different topics. So I'm happy to answer any questions that may have come up.
And feel free to use the questions panel on the right side in your toolbar, and I'll read them off. Can you get us a PDF copy of the actual slides? Yes, I will be sending a follow-up email after this webinar concludes with the recording of the webinar, as well as the PDF and a GDPR readiness checklist as well.
And by the way, I'll add, I do have other tools. So for example, if GDPR applies, I have a kind of a tool checklist in terms of how you get explicit consent. I have another one in terms of what needs to go into your privacy policy. So I'm happy to provide those as well. In regard to data audit, those are, I mentioned that before when I helped my clients kind of do a general data audit to get a handle on the data they're collecting and how they're sharing it and how it's being protected. That's tailored a little bit more to an organization because depending on what the organization does, certain questions need to be asked, others don't. So I'm happy if someone reaches out to me, I can kind of tailor that better to their needs and get them something.
We got a question here. Can you expand on what you had just mentioned about holding on to a user's data for 4 years, but they didn't opt in? How should we best deal with their user accounts' email preferences?
Yeah, that's a really good question. So, and this is really under GDPR, but again, I think at some point the U.S. are probably moving to a similar stance. And let me preface my comment by saying it's more of an art rather than a science. But at least in regard to GDPR, you need some sort of explicit consent. Let's say they made a one-time donation under my example. They did not opt in for newsletter or anything else. And they didn't do a recurring donation. So really, you may not have emailed them again. At some point, if they haven't reached out, they haven't done anything else with your organization, from an EU perspective, that data should only be kept for as long as is reasonably necessary. So think about legal reasons to keep it. There's a certain amount of time after credit card transaction, you want to keep a copy of the record. But I would say after 12 months, and under that very limited circumstance, you no longer need that data. I know organizations like to do, believe me, all my clients like to keep this data for as long as possible, right? It's information that can be valuable, but I always counsel, and this has nothing to do with the EU, I counsel clients to really think about a data retention and deletion plan and only keep the data that's useful, right? If you're having data, and most organizations just never get rid of data, a lot of data, if you look from a statistical standpoint, probably isn't useful in terms of your fundraising, your outreach. Get rid of it. Again, it's an art rather than science, so you have to think about what's reasonable under the circumstance. One thing I'll also add from an EU perspective, there's no grandfather clause. So if you have information on EU residents now, after GDPR went into effect, technically, you need to reach out to them if you haven't gotten explicit consent, and probably most organizations haven't, given the fact that the way we've been doing it for several years past. You would need to reach out and again ask them for consent to continuing to work with them.
As a social service nonprofit serving clients locally, how would we determine if GDPR would apply?
Yeah, it probably doesn't, but if you, because again, the reason is, would you have people from the EU logging on, accessing your site, and giving you personal information? So the question, the answer to there is probably not. But even if you happen to get once in a while one person here or there, I mean the risk associated with having 1 or 2 or 3 names is obviously much different than having hundreds or thousands of names. So I would say anybody with, again, as a lawyer, I would say even if you have one, the law applies. But if you're a local social service organization, odds are it's going to be very low risk of that type of information. But if you are more of a national nonprofit or even a regional nonprofit that gets people visiting, that could get people visiting from the EU, you should think about, at the very least, updating your privacy policy and looking at the way you get consent. Because again, those are the low-hanging fruit. And if you're doing at least those 2 things, you're in better stead than other organizations.
How would PII and PHI data overlap?
Oh, so protected health information at PII. Well, PHI is considered sensitive data. So we talked about the difference between regular PII and sensitive PII. Basically, I would say PHI is considered to be sensitive PII, so it needs to have a higher level of protection. You definitely want to only keep that for as long as you need it. You need to think about, is there a rationale for why you're collecting it? For many organizations, obviously that there is, but for some there may not be. And if there is, just make sure your security practices, your privacy practices, if you need to have BAAs in place and for a business associate agreement, just make sure that the relevant regulations are being met.
Just wait a minute or so for any more questions you guys have.
Oh, well, while we're waiting, let me just add one other thing. This is both for GDPR, but I would say any vendor agreement. Again, I still think that what I see is the biggest risk to most nonprofits in terms of any kind of cybersecurity event typically comes to a vendor. So when you do this data privacy security audit, make a list of all the vendors that have access to your information. Odds are those agreements are in place. Any new ones, think about the provisions I told you that you should be addressing for any new agreements. But for the ones that are in place, keep in mind when they're going to come up for renewal, right? There's always a renewal. And then don't let it auto-renew. Let them know that you want to renegotiate the agreement. And then think seriously about addressing a lot of the provisions that I suggested. Because at the end of the day, I think the biggest bang for your buck, if you will, is renegotiating and putting proper provisions in your vendor agreements to help protect your organization should something go wrong.
All right, well, if you guys no longer have any more questions, we'll be wrapping it up. John Darley, thank you so much. Oh, wait, we got one question just came through. I'm sorry. How hard is it to renegotiate agreements with organizations such as Salesforce, etc.?
Great question. So there are two types of Salesforce agreements. Some I know nonprofits, if they're small enough, there's no fee. That makes it a little harder. I mean, obviously with all these agreements and the ability to negotiate, right, it's the leverage. The example I gave you before about a very large kind of national nonprofit working with the black bond agreement, we were able to make wholesale provisions, add pages and pages, and they work with us because it was a big account. If it was a much smaller account, most vendors will still negotiate. Salespeople want to get these things closed. All vendors care about the revenue. So assuming you're paying anything, you can negotiate a lot of these provisions. To the extent to which you get uncapped damages, to the extent to which you get some of these things will depend upon, the value of the contract. That being said, I've negotiated Salesforce agreements. I mentioned Blackbaud, almost any vendor agreements I've negotiated, and depending upon the size, sometimes you get more, sometimes you get less, but you always get, let's put it this way, you always get a lot more than their first draft, right? So I've never had anyone say, I've said it before, ever had anybody say no to the breach notification costs and to the transition services. Didn't depend on the size of the deal. Those were two things, for example, that always goes in. Some caps exempt out from the limitation of liability. I almost always get, and again, the level that we get and how much we get and how aggressive we can get does depend on the size of the deal, but changes can always be made.
What would be the ballpark figure of retaining services to look at the organization's contracts?
Oh, good question. Good question. It depends on. I mean, I'm a lawyer. I have an hourly rate, so it would be, if you gave me a sense, I could, with all the work I do on behalf of my clients, I'm pretty good in most cases of giving a range, meaning, and it won't ever be above the range. If it goes above, then it's my time. It's hard to say only because if you have 2 or if you have 10. Typically, to do a quick review of an agreement and just kind of say what the trouble points are, what the things you should renegotiate for one agreement would probably be less than an hour, just to give a high level kind of review. If that turns then into a negotiation, again, it depends on the size of the agreement, the complexity of the technology, what the vendor has access to. So it varies, but I'm happy to kind of give more specific information and better parameters once I have a little more information.
I will just wait another minute for any more questions to come in.
That's fine. And as always, like, people feel free to, if you want to send me an email or pick up the phone, I'm happy to answer any questions you might have.
All right, John. Well, thanks so much for doing this webinar for us, and thank you to all of our attendees for coming. Be sure to check out our website for more upcoming webinars, and we will get a follow-up email out as soon as we can with some more information. So thanks a lot, guys.
Thank you all. Bye-bye.